hi. A few months ago, in fact it was about 6 months ago, I sometimes put my name into Google just to see what comes up. And I got a bit of a fright because I found that there were 4 entries for Gray's online auctions, selling 4 of my works. And the 4 works went for very small prices. And I just didn't know where it came from because it certainly wasn't me. So I tracked back and started feeding in some information into the computer, and that's when I saw that the gallery that I had been operating with, which was Smith & Hall, had gone into liquidation. And so consequently I wrote to the gallery didn't exist anymore, so I wrote to the liquidators. And that's when they told me that no, I didn't have any right either over the paintings or over any of the money that they were sold for. So basically $10,000 worth of paintings had been transferred to someone else. And I must say that, well, I've been fighting it ever since and still hasn't got anywhere. So that was my experience.
Basically what Camille did when she brought her artworks to the gallery is she consigned them. And consigning is basically when you bring artworks to a gallery or to an agent with a view of this person selling them on your behalf as your agent. When you consign work, usually, at least before the act came into force, you as an artist do not transfer property, physical property, or what lawyers call title. You remain the owner of the artwork, which is in the possession of your gallery. So basically, in a situation such as that of Camille, when the gallery becomes insolvent, the liquidator who comes in and deals with the insolvency should assess what are the assets of the gallery. So it can be the furniture, it could be any artworks which have been sold to the gallery where title has passed, and should separate all the works consigned with it from the assets it actually owns, to which it has title. Only those assets that the gallery owns can be part of the assets which will be used to pay creditors. Obviously, something went very wrong in Camille's case because the liquidator didn't ascertain that the gallery did not have title to these pieces and just dealt with them as any other assets and sold them and used the proceeds to pay the other creditors of the gallery.
So the reforms, the Personal Properties Securities Act, kicked off on the 30th of January, midnight on the 30th of January 2012. It affects a lot of people. It affects consumers and businesses that are buying personal property, anyone who borrows or lends money, purchases or sells goods on consignment or on credit, retention of title. It affects people growing crops and so on, or who own and lease machinery or vehicles. So it affects a lot of Australians. Some people have said it's as big a reform as the GST was. So that's kind of how big it is. And the phase we're going through at the moment, I think, is people are starting to understand how big this reform is, and events like this are great because it's the more people that understand what it is and how it works, the better it will be for everybody. Okay, so this slide here is about the most common scenario involving personal property security. The secured party, that's the person who has the security interest. Very commonly, they would be a lender. A lender would take security over a motor vehicle or something to secure a loan. But they can also be somebody who supplies goods, supplies personal property on retention of title or on consignment. They could also be a lessor or somebody who leases goods. A security interest is really what this legislation is all about, and it's defined as an interest in relation to personal property provided for by a transaction that in substance secures payment or performance of an obligation without regard to the form of the transaction or the identity of the person who has title to the property. Now that's a whole bunch of legal jargon, but what it boils down to, what it's trying to convey, is that, as Rebecca was saying, the law no longer looks at title so much, but it's looking for the substance of the transaction. So what the law is trying to do is say, if you have something that in substance secures payment of an obligation or some other obligation, normally it secures payment of an obligation, it doesn't matter what you call that transaction, we're going to say that that's a security interest, and if it is a security interest, then the rules in this legislation will apply to it, including the rules about registering that security interest. So basically it's about substance over form. And the key implication of that, especially for people selling goods on retention of title or consignment, is that before you didn't think it was a security interest at all. It was basically just, well, I own this and you might happen to have it, but I own it. Well, now the law is saying, well, no, because in substance, let's take a retention of title transaction, for example. In substance, what you're doing is saying, well, I'll keep the title to the painting. Why do you want to keep the title? Because you want to secure the payment of the purchase price back. So your interest in those goods is securing payment of a debt. And because that's the substance of the transaction, this reform is saying we'll call that a security interest. So I'll now talk about collateral. You've probably heard the word collateral in other contexts, and it basically means what you would think it would mean. The collateral is actually the personal property over which the security interest is held. So if you borrow money to purchase a car, and the finance company takes a security interest in the car, well, the car is the collateral. In the case of selling goods on retention of title, then if somebody's supplying goods to a shop on retention of title, well, the collateral will be the goods that are supplied. The grantor is the person who basically grants the security interest. So in the case of a loan transaction, the grantor would most commonly be the borrower. In the case of a retention of title or a consignment type arrangement, the grantor is going to be, well, in the case of art and gallery, the grantor would be the gallery. So they're the person that owes the payment or owes the obligation to the secured party. Commercial consignment, this is one where you'll probably be more interested in. A commercial consignment is defined in the legislation as being where a consignor delivers goods for the purpose of sale, lease or other disposal to a consignee. So in the case of artist and gallery, the consignor would be the artist and the consignee would be the gallery. The requirements for this definition to be satisfied are that both parties deal in goods of that kind in the ordinary course of their business. So basically both parties deal with artwork as part of their business. And that the consignor retains an interest in the goods. Carved out of that definition are goods delivered to an auctioneer or delivery to somebody that the creditors of that person generally know that they are dealing with goods sold or leased on behalf of others. So that's just the definition of commercial consignment, and I'll come back to that because that's something that I think you're probably quite interested in. This is one of our lovely new acronyms, and people call this a PMSI, PMSI, Purchase Money Security Interest. It's a special type of security interest and it's basically taken to secure the repayment of purchase monies. PPS leases and commercial consignments are both examples of these purchase money security interests, and the reason they're special is because they have a super priority. So they get priority if there's ever a competition between different security interests in the same property. PIMSs will usually be a better interest to hold. Perfection is a state where if you're a secured party, that's what you want to have. You want to have your security interest to be perfected, as they say. And in order to be perfected, you need three things, and they don't necessarily have to occur in a particular order, but you need three things. First of all, the security interest has to attach to the collateral. And I won't go into the detail of how that occurs, but basically it occurs when the grantor gives value or does something else that allows the security interest to be enforceable against the grantor. So at that stage, once you've got attachment, then there's an agreement between the grantor and the secured party. Next, it needs to be enforceable against third parties. So you need to go a step beyond saying, well, I've got an agreement, A has an agreement with B. That agreement needs to be enforceable against other people. And for that to occur, there needs to be a written security agreement over the collateral. So to enforce it against third parties, there needs to be a written agreement, and that's something that I'd like to emphasise. So under this legislation, if you're doing consignments or selling on retention of title, it's very important that for that arrangement to be written down. And then finally, the best protection for a secured party is obtained if it's perfected, which requires this extra step of either registration on the Personal Property Securities Register, or for the secured party to actually possess the goods. Now, the idea of that is if the secured party has possession of the goods, then it's fairly clear to everybody around that they must have some kind of an interest in the goods. But most of the time, the whole point of the security interest is to allow someone else to possess the goods. If you're selling goods on retention of title to a shop, there's no point in keeping those goods back in the warehouse. You want those goods to be out in the shop so that the shop can sell them on. So the most common way for people to perfect their interest will be to register their interest on the Personal Property Securities Register. Generally, if you've got a security agreement, it won't give you security only over the collateral, because if your security is a motor vehicle and the motor vehicle is destroyed or crashed or something else, then you've lost your security. So you want to be able to actually claim the insurance proceeds as well. Similarly, if you're selling something on retention of title, you want your security interest not only over the goods, but because those goods are going to be walking out the door, you want the security interest to capture the cash that's exchanged for the goods. So the proceeds are kind of the value that can be generated from the collateral. I'll just say a few things about consignment, because I understand that often this is how artists deal with their works. They sell on consignment. Now, as Rebecca mentioned, there is a big change in this area. Before, if you had a retention of title agreement in your consignment agreement, or if the agreement provided that you hang on to the title, then what should happen is that if something goes wrong, that it's recognised that you have the title. Now, if you're, because those sort of arrangements are deemed to be security interests, the new rules apply, and so unless your interest is perfected, as I described before, part of that, and the key elements to that are a written agreement and registration, then the Act has provisions that if the consignee goes insolvent, then basically the interest is vested in the consignee. So effectively what happened to Camille, which shouldn't have happened, is actually will happen, but if you do have a written agreement and you do register, well then there is protection, and in fact not only will you be treated along with all the other creditors, but you should be treated better, because you will probably have a PIMSI or a purchase money security interest. So if there's a liquidator dealing with that, then your interest would be recognised.